Welcome to Resilience and Resolve with Lance Drury.
Welcome back to Resilience and Resolve. I'm Evan Mack with Lance Drury, and today we're talking about bank levies, which is when the IRS freezes your account and takes your money. How does it happen, and what can you do to stop it? Welcome back, Lance Drury, sir.
How are you today, Evan? It's always great to see you.
Oh, I'm hanging in there. Can you tell the people at home what is a bank levy?
A bank levy is when the IRS issues a levy, which is an actual seizure of property, and they send it to the bank. Now, the bank has an obligation they freeze your account for that amount, and they're under an obligation not to send it to the IRS for 21 days. So what happens is people call me after they get a bank levy, and then we got to get financials together and all that, because we have to prove to the satisfaction of the IRS, in order to get that bank levy lifted, that it would be a financial hardship on that individual not to have those funds. So basically, we got to show through their income and their expenses that they're not going to have the ability to pay all their bills. Now, the thing that's fascinating about a bank levy as opposed to a wage levy is continuous. The bank levy is only good on the day that it hits the bank. That's when the 21 days start. So it's very seldom the date on the levy notice, because they got to mail it to the bank. So it's going to be a few days before the bank gets it. But the significance of a bank levy is, even if you've been levied on your bank, the monies go into the IRS, they can do it again. So they can issue successive levies on a bank levy.
So what's the difference between the lien and the garnishment as opposed to the levy?
Well, a garnishment is basically a levy. A garnishment is a seizure of property. A garnishment is what I would call a subset of that. Mostly you're dealing with garnishment on your wages, but it's still a levy. Now, the difference between a lien is that is not an actual seizure of property. The lien is filed with the recorder of deeds in the county in which you live. Sometimes they don't file them in the county in which you live, and guess what? Then the lien doesn't attach, because that lien only attaches to property in the county in which it is filed. But the significance of that is, if you ever go to sell your house, then that lien has to be satisfied at the time of sale. Now, the IRS says there's an invisible lien. There's a lien regardless of whether they actually file it or not. But they file that lien so that they take priority over other creditors. And the IRS also takes the position that that levy is for any property, personal, real estate, whatever, that you have acquired at the time that the levy hits, and the lien, and any property that you acquire thereafter. Now, the lien's not good forever. It's supposed to be released 6 to 9 months before the collection statute runs out. But the IRS is so screwed up now. They're so far behind. They have so few individuals that now people are having to hire me to get those liens released. They're supposed to be self-releasing, and there's a last date on there for the IRS to refile the lien. But these title companies, when people sell their properties, they're not honoring that. They either want them to pay it off, or they have to get a release of the lien so that lien doesn't have to be satisfied at the time of sale. So people want to do it because the IRS no longer has the power to collect against them, but that doesn't matter to the title company. So we got to get that release of lien for our clients.
So what kind of notice does the IRS give before they, freeze someone's account?
Well, the IRS has to go through a sequence of letters before they can seize your bank account or garnish your wages or anything else. In 1998, Bill Clinton got with a Republican Congress and passed all these procedural safeguards for taxpayers. Before that, it was like the wild, wild west. They could just go in and levy you, and revenue officers would do it all the time. No prior notice. We're just taking your money. Well, now there's a sequence of letters that have to be sent out. Some of them act like they can take your money now, but they can't because it doesn't contain your appeal rights. But when you get down to a CP90 letter, letter or an LT11, 30 days from the date of that notice, you better file the proper legal paperwork to stop the levy, or the IRS is going to be in a position to levy. That's called a collection due process hearing. And it buys you 6 months or longer to get your ducks in a row so that you can work out a formal agreement with the IRS. Now, there's one caveat to that, and I think we discussed this in another segment, Evan, is that if the collection statute is going to run out in a year or two, you don't want to file a collection due process hearing for the most part, unless you want to go to U.S. tax court, because it stops the running of the statute on collections. You want to wait beyond the 30 days because the IRS is not going to file a levy the next day, and file what's called an equivalency hearing. And the significance of that is you still get the hearing 6 to 9 months down the road. But guess what? The clock on collections continues to run. In fact, just earlier this month, I've had a client for a while, and we decided we were going to run out the clock on collections. He owed $90,000. And once he was in C&C status, I even called him up, got it. They needed managerial approval, and they never got managerial approval. You know, I've said before, the IRS is making all kinds of mistakes. Things are not getting done which should be. And so it came down. He finally got a final notice of intent to levy, probably late last year. So we didn't file a collection due process hearing. We filed an equivalency hearing because the clock on that $90,000 runs out in September. What further delayed it was, and this is how bad the IRS is, and not just me, but a lot of my attorneys are finding this out. They are switching appeals officers all the time. You start with one, then you go to another, then you go to a third. So this guy's equivalency hearing got delayed 2 or 3 months just because they kept switching him around. But
can they take everything?
That was all to my client's benefit, so we didn't care.
Yeah, it sounded like in that case it kind of helped out.
It really did. It really did. And so, you know, there's no way. I'm sure it's not even back in collections yet. It probably won't get back in collections till late July, maybe even August. They got a month to collect. So the ball game is basically over on trying to collect from my client. Speaking
of collections, though, can they take everything in your account? Is there a cap? Is there a limit, or can they just take it all?
They can take it all. And
wow.
in fact, now there are certain exemptions. If you get a levy, you can file out a list of exemptions because you have children or whatever. So that can prevent all of it from being. That's normally not with a bank levy, but with a garnishment levy. But here's the thing. Let's say the levy is for $50,000, but you've only got $10 in the account on the day the levy hits. The IRS can only get $10. And in that case, we wouldn't even try to get the levy lifted. So, you know, a lot of people, even though they owe a lot of money, depending upon the day it hit, they may have paid all their bills out of that account before the IRS levy hits, and so they're not going to get a whole lot of money from that particular levy.
What about rent and medicine, payroll, like life? You know what I mean? They can still take that kind of money from you?
They can, until you prove to them that it would be a financial hardship. So they're going to take all those factors into consideration after the levy hits if you're trying to lift the levy. But before the levy hits, they're not, because here's the problem. I had a guy once that walked into my office in St. Louis, and he looked like he was half dead. And when he sat down, I said, "What's wrong?" And he said, "I've been living in my car for over a year because the IRS is leaving me $200 every 2 weeks to live on." And so at that point, he didn't have the means to hire me, or he didn't have any money at all. And so the problem is, sure, we could have gotten it lifted in whole or in part, but, you know, the IRS does not pay attention to your financial information before they will issue a levy. You have to prove to they don't have the funds to go out and say, okay, Joe Blow pays this much. You know, the burden is on you to prove all that. And so they're not going to do all that legwork for you. And they don't have the resources to do it. And so then when they come to you, you have them get all that information together, and then you call up the IRS, and then you get the levy lifted in whole or in part.
Can it be reversed? Can a levy be reversed once it hits or no?
Well, it can if it was wrongfully issued, and that has happened in certain instances. But again, if you can prove that your client is in a financial hardship, it has the same effect of getting it reversed because it's going to be lifted.
What about, more than once? Can the IRS continue to levy you? Can this go on? You know what I mean? Or can once they levy you, that's it? Or can there be multiple levies?
Oh, no, there can be multiple levies. As I said earlier, bank levies can be successive. They're only good for the day they hit. After the money's set in, they can issue another one. And I've seen that happen several times. The garnishments are continuous of your wages until you get it lifted. So if you sit there and do nothing, and some people do, their wages are garnished for 6 months to a year until the levy on your wages is satisfied. But guess what? Even if you get it lifted, you get an agreement set up with the IRS, you're paying on that agreement, you're compliant moving forward, they can't levy you. But you miss that installment agreement payment every month, or you incur additional liability with the IRS, they can levy your wages again. So, once you get a deal with the IRS, you have to be 100% compliant moving forward, or you're going to be back to square one.
Are there any accounts of any kind that can be protected from a levy?
Well, there is a certain type of investment account that you can put your money in. I don't want to disclose that here, but but if you do that, it's not considered a fraudulent conveyance because you're exchanging it for fair market value and the IRS can't touch it. But that is the one thing. The problem is if you have tax, because people ask me all the time, well, I'm just going to shut down my bank account or I'm going to transfer it to a different account. And I said, you can't do that. That's a fraudulent conveyance. But here's what they can do. You can't take that money out. There's nothing to restrict you from opening up a new account. You just can't transfer the money. So continue to pay down expenses on that account that they're coming after and then use the new bank account later. But it is considered a fraudulent conveyance if you do that. I'm going to give you a small example. I had a guy came to me at the 11th hour, and the IRS had filed a suit in federal district court in Springfield, Missouri, and they were coming after his home because he owed over $200,000 in trust fund civil penalty taxes. And the home that they wanted was his estranged wife was living in. And years ago, while he had the tax liability, he deeded his 1/2 interest to his wife, just gave it to her, quitclaim deed. So they filed an action saying this is a fraudulent conveyance, set aside the conveyance, sell the property, give her 1/2 net equity in the home. The IRS gets the other half. And so I was negotiating with lawyers out of Washington, D.C. There was a lot of time spent on the phone with them. And they have costs of seizing the home. They have costs of this, and that. So we ended up settling that $200,000 plus debt for $60,000 to $70,000, and everything was done. And the estranged wife was able to keep her home.
So, what steps can someone take to stop a levy before it hits? Can you tell the people at home what they can do?
Well, again, the IRS has to go through a sequence of letters. So one of the things that you can do what? Set up an agreement with the IRS. And as long as you're paying on that agreement and you don't incur any further liability, they're not going to come back later and levy you. The other thing is you can file a request for a collection due process hearing or an equivalency hearing to stop the levy and to buy yourself 6 months or longer to get an agreement with the IRS, which will stop the levy as well.
Now, what can a Lance Drury or any kind of tax attorney do to help prevent or reverse a bank levy, sir?
Well, what you can do is you can hire us and we will have to submit financial statements. And that's where you get the biggest bang for your buck when you hire us, because nobody fills out those financial statements right. I was telling somebody this morning, I have people and they get through the financial statement on their own. They say, well, they can pay $1,500 a month is what it shows. Well, I know they can't pay that. Those forms are confusing. They're complicated to the average individual. And so that's what our assistants can do for people, because we can tell people, we can give them advice on how to structure their assets and their expenses to get a better deal from Uncle Sam. And so that's what our firm can do to protect your interest, to get a levy lifted, and to give you your life and your peace of mind back.
Amazing. Thank you kindly, Lance Drury, sir, for your time.
Thank you, Evan. Can't wait to see you again.
Absolutely. And don't wait for a bank levy to drain your account. Visit lancedrurylaw.com and put a plan in place before the IRS acts. Thank you for watching.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.